You're sitting in a police interrogation room. You're scared. You've been questioned before. The detective keeps pushing. So you do what anyone would do. You ask for a lawyer. You say, "Why don't you just give me a lawyer, dawg?" The detective doesn't stop. No lawyer comes. You keep talking. You say things you shouldn't. You appeal. The case reaches the Louisiana Supreme Court, and a justice writes, in an official published opinion, that your request was too ambiguous to count. Why? Because according to the court transcript, you didn't ask for a lawyer, dawg. You asked for a lawyer dog, and no such animal exists. I want to be clear about something before we go any further. The man in this story was convicted. The charges were serious. First-degree rape of a child. This video is not about whether he deserved to go to prison. This video is about the mechanism that was used against him. Because that mechanism doesn't disappear when the defendant is guilty. It's still there, waiting, for anyone who sits in that chair. October 2015, New Orleans, Louisiana. Warren Demesme is 22 years old. He is brought in by NOPD detectives for questioning in connection with the sexual assault of 2 juvenile victims, both minors under the age of 13, one of them his own cousin. The charges are among the most serious in Louisiana law. First-degree rape carries a mandatory sentence of life in prison without the possibility of parole. No exceptions, no discretion. Demesme agrees to be interviewed, voluntarily, twice. Both times, detectives read him his Miranda rights, the constitutional protections that have existed in American law since 1966. Both times, Demesme says he understands. Both times, he waives those rights and agrees to talk. He is not tricked into the room. He walks in. But during the second interview, something shifts. The questions get sharper. The pressure builds. Demesme has repeatedly denied the charges. The detective keeps going. And then Demesme says it. The sentence that will define his entire legal fight and eventually be read into the record of the Louisiana Supreme Court. If y'all, this is how I feel. If y'all think I did it, I know that I didn't do it, so why don't you just give me a lawyer, dawg, because this is not what's up. The detective does not stop. The interview continues. Demesme makes statements that become the prosecution's central evidence. His public defender, Derwin Bunton of the Orleans Public Defender's Office, files a motion to suppress. The argument: Demesme invoked his constitutional right to counsel. The police ignored it. Everything after that moment should be inadmissible. The motion is denied at trial court level, denied again on appeal, and then it reaches the Louisiana Supreme Court. Here is where the story becomes something else entirely. The court transcript recorded Demesme's words as, "Give me a lawyer, dawg." No comma, 2 words. Lawyer, dawg. Pause on that for a second. Anyone who has spent 10 minutes around American English, any variety of it, knows what dawg means. It is a term of address. It means man, dude, bro. It is not a noun describing an animal with 4 legs and a law degree. When Demesme said, "Give me a lawyer, dawg," he was saying, "Give me a lawyer, man." The request was clear. Dawg was punctuation, not a noun. But here's the thing. The comma was not in the transcript, and Louisiana Supreme Court Justice Scott J. Crichton, writing a concurring opinion he chose to publish, specifically, as he said, to spotlight the very important constitutional issue, treated lawyer dawg as a single compound noun. His conclusion? Since no such thing as a lawyer dawg exists, the phrase could not be an unambiguous request for counsel. I want you to sit with that for a moment. A sitting justice of a state Supreme Court, in a published opinion, in 2017, argued that a man's request for a lawyer was invalid because the court transcript omitted a comma and no attorney dawg exists. But here is what almost nobody reported correctly. The comma was not even Crichton's own interpretation. It came from the Orleans Parish District Attorney's Office, which included the phrase in their brief without punctuation. Crichton adopted their framing, and it became official court record. The Washington Post covered it. Slate dissected it. The Federal Bar Association published a piece titled, "The Unspeakable Comma Has Claimed Another Victim." Legal academics wrote about it for years. But the deeper issue, the one that actually decided the case, was not the comma at all. Stay with me here, because what I'm about to explain is what actually decided this case, and it is more disturbing than the meme. Justice Crichton didn't just rely on the comma. He cited binding federal precedent, Davis versus United States, decided by the U.S. Supreme Court in 1994. In Davis, the Supreme Court established what legal scholars call the unambiguous request doctrine, the ruling. After a suspect has knowingly waived their Miranda rights, police may continue questioning unless and until, quoting directly from the opinion, the suspect clearly requests an attorney. The standard is whether a reasonable police officer in those circumstances would understand the statement as a request for counsel. Crichton applied that standard to Demesme and concluded, no reasonable officer would have understood lawyer dog as a clear request. Now, here is the problem that legal scholars identified immediately across the political spectrum. The Davis case involved a suspect who said, maybe I should talk to a lawyer. Maybe. A clear expression of uncertainty. A genuine hedge. Demesme didn't say maybe. He said, why don't you just give me a lawyer? In everyday American English, in any register, that is an imperative. It means, give me a lawyer. The Davis court was explicit about one thing. Suspects, quoting Justice O'Connor, need not speak with the discrimination of an Oxford Don. They do not need to use precise legal language. They just need to get the point across. Demesme got the point across. Any reasonable person in that room would have understood he was asking for a lawyer. The Criminal Law Practitioner's Journal put it plainly. The Davis standard can be manipulated by courts to conform to their own syntactic preferences. And that is exactly what happened here. There is also a dissent in Davis that matters. Justice Souter, joined by 3 other justices, warned in 1994 that the unambiguous request standard would be used to rationalize ignoring legitimate requests for counsel, especially from people who, under pressure and fear, do not speak in legally precise terms. That dissent was written 30 years ago. It described this case exactly. Warren Demesme is black. He was speaking in African American vernacular English, AAVE, a linguistic system that has been studied and documented by linguists for decades. It has its own grammar, its own phonology, its own rules. It is not broken English. It is a complete dialect spoken by millions of Americans. Dog, as a term of address, is not obscure or regional. It appears in mainstream American music, film, television. It has been used on national broadcasts. It is not a linguistic mystery. A forensic linguistic analysis published in a peer-reviewed journal concluded directly, Demesme was not requesting a lawyer dog. He was using what linguists call a vocative address term, dog functioning the same way man or dude would in the same sentence. The request was clear to any fluent speaker of American English. And here is the part that makes the Davis standard particularly dangerous in this context. The reasonable police officer test gives courts almost unlimited discretion to decide what counts as clear. If the court decides, or the transcript suggests, that the words don't parse in standard English, the request can be dismissed, no matter what the person actually meant, no matter what anyone in that room understood. The practical result is this. If you are interrogated while frightened, if you speak in a dialect the court doesn't recognize, if a comma is missing from a transcript, your constitutional right to an attorney can be legally set aside. Not because you didn't ask, because you didn't ask in the right way. Demesme was convicted. He faces life in prison. His incriminating statements, made after he asked for a lawyer and was ignored, were used against him at trial. The ruling in his case remains valid precedent in Louisiana. Here is what I think this case actually reveals. The Miranda warning tells you, you have the right to remain silent. You have the right to an attorney. What it does not tell you is this. You must invoke that right in grammatically precise, standard American English. You must do it at the right moment, in the right form, with the right words. Because if you're scared, if you're under pressure, if you naturally speak in a dialect this system doesn't fully recognize, a missing comma in a transcript can cost you a constitutional guarantee. The Supreme Court said suspects don't need to speak like Oxford scholars. Louisiana courts effectively required exactly that. I want to be precise about what I am and am not saying. I am not saying Warren Demesme was innocent. The evidence suggests he was not. I am saying that the mechanism used to admit his statements was broken, and that broken mechanism is still active. Still valid precedent. Still waiting for the next person who sits in that room and asks for a lawyer in the wrong words. The Constitution is supposed to be the floor, the minimum protection. What this case shows is that the floor can disappear under your feet, based on punctuation, based on dialect, based on how a district attorney's brief formats a sentence. That should bother you. It should bother you regardless of what you think about Warren Demesme. If this case changed how you think about Miranda rights, or the next time you'd talk to police without a lawyer, subscribe, because next week I'm covering the exact words courts have ruled are sufficient to invoke your right to an attorney, and the phrases that look like they should work, but don't. And leave me one comment. Did you know this case before today? And did you know the comma wasn't even the real issue? See you next Saturday.